This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Explain to your Lord. So, Bandhavadhyay, it will be really proper assistance to this court if I put you two questions.
Yes.
First of all, this is a cabinet decision. And pursuant to that cabinet decision, there was a direction to the School Service Commission under Section 19 of the 97 Act. How far this executive action or the legislative, whatever way, kindly explain this bridge.
Well, first of all, kindly see the cabinet decision has not been challenged before a lot.
No.
If the cabinet decision has not yet been challenged, your lordships cannot touch that cabinet decision.
No, I cannot.
No.
Cabinet decision.
The cabinet decision remains. If the original remains, on the basis of any executive order is passed, what is wrong? Because executive power is coextensive with the legislature. Let's assume today. Your lordship is set as just argument sake, these administrative directions. Correct? Let's assume. Now, I can't legislate the law. I mean, state can legislate the law on the basis of coextensive power. The law is there, but saying that the coextensive power of executing.
Mr. Banerjee, I don't think that it is required to be brought to your notice. It is not the decision. It is the decision-making process.
No.
Which is open.
No, my lord. No. Even the decision-making process of the cabinet is not under challenge, and your lordships cannot go into that questions.
Constitutional immunity.
Yes. Then, if the court can interfere with the cabinet decision in every day, whole India will stall.
No, of course not. It's not me. It is the decision-making process.
Process means what? Here, on the basis of that, executive instruction has been issued. The state is having the power, coextensive power of the executive power in a field while law can be legislated by the Schedule 7 under list 2 by the state. The executive power is also for that Schedule 7 list 2 or the concurrent list. What is an executive power can be said to be bad? When state cannot legislate a law in respect of a different field, then the law is bad. Suppose state legislature is legislating a law in relation to list 1, then it is bad.
No, I understand. But what is my query from you? That the legislature, the cabinet took a decision, but while implementing that decision, the executive acted in excess of that.
No, executive has not acted. My lord, kindly see what is the decision of the cabinet. So, cabinet decision, kindly come to cabinet memorandum. Page koto? They have given
supplementary stated. Here, petitioner is supplementary.
It's puro.
Petitioner, what is the date of your supplementary? Where the cabinet decision is a part of it.
24th of April 2025.
20?
24th of April.
No. এটা বিচারটা ফার্স্ট ছিল দিন তো নামটা কি মাদিব ছিল
This is 19th June 2005.
আজকে ছিল পিটিশনারে বাঁচালো না ওকে ওই মামলাটায়
খুঁজে খুঁজে বার করাই তো মুশকিল 19 June kindly read this
এইটা দিয়ে দেখানো তাহলে ওরা ওরা ছেলেটাকে
and you see the Commissioner of School Education via its proposal dated 4th May 2022 has proposed to create 16,000 number of supernumerary posts, break up 700 so and so to absorb all waitlisted candidates.
You are reading from
Page number 3.
page number 3.
না কত? Page কত?
3 of 7. 3 of 7. At the bottom, kindly see 3 of 7. My senior is placing which
3 of 7.
yes. My senior is placing page 4. 4 of 7 top. Top.
Yes.
The Commissioner of
II.
The proposal of the Commissioner of School Education. The Commissioner of School Education via its proposal stated so has proposed to create 16 number of supernumerary posts, break up 750 work education assistants to absorb all waitlisted candidates of physical and work education teachers subject to validation of the post. Right. But who is challenging this? Unsuccessful.
Yes, waitlisted.
Unsuccessful. Who is challenging this? Unsuccessful persons. What is rights come in? If let's see your lawsuit strike down, they will get the appointment. Court will take into all the facts. Every lapse of law doesn't call for interference by the court. That part I will give, one judgment I will give it later by junior. Every lapse of law. Court is not for that reason. What is it? Here is wrong. Set aside. Article 226 court doesn't see it for that. It's a court of equity. Equity not for the petitioner even only. Equity for the others also. Read jurisdiction is not a one-way traffic. It's a double-way traffic. What the benefit you will? How he has prejudice? First question. How you are prejudiced? If you have not prejudice, no case. Your lordship is not here to decide academic questions and unnecessarily striking down the orders and unnecessarily creating the problems. Whether he will be benefited, if he is benefited, give it. Who is not prejudiced, nothing, not such. What has happened now in West Bengal? हमको खाना नहीं मिला तो किसी को खाना नहीं देंगे. Few groups are there now in Calcutta High Court.
They are talking in
19. I am rushing from this court to that court to that court to save. Going on to and continuing the matters. Bidjoy Atta. Atitya Atta. What can I do? You can't do anything in West Bengal now because of few persons. And all they have failed in every examination. I think they were, when Justice Ganguly was there, they were very good. But thereafter, what has happened? Whole wave has been changed when Justice Ganguly was there. But those who are getting all their incompetent and those who have come, they are very competent. After they have got chances, not got it. They are not getting it. Anywhere, upper primary, primary, anywhere. Now, your lordships kindly consider first why your lordships will examine the issue at all. What benefit? Whether court will decide the question for academical reasons or court exists only to put some persons under the troubles? Is it the court's function to do it? This is not a public interest litigation. This is not a public interest litigation. Even a public interest litigation service matter, court cannot interfere. No, this is not a case where the malpractices have been alleged. But here is the case, your lordships will not go to the OMR 6 at all. That is not the scope of the writ petition. My lord, your lordship was in the civil, your lordship know very well that pleading is an essential part of a case.
Of course.
And in support of his pleading, evidences will come. And in read jurisdiction law is, Bharat Singh's case, Bharat Singh's case, paragraph 13, just a minute. Whatever you have said in the writ petition, annexures, oppositions, annexures based on that, not a statement from the bar.
এটা তো কম্পাইলেশনটা তো
No, I am reading this, just Bharat Singh, I will give it. আচ্ছা ভরত সিংকে দিয়েছিস এখানে দিয়েছিস it is not here, I will give it.
আমাদের কম্পাইলেশনটা
ভরত সিংটা আছে দিয়েছিস দিয়ে দিবি পরে আবার give it. I will give Miller Bharat Singh. Just I have thought about. I am just telling you paragraph 13 lordships kindly record it. Will be give. Two questions first come.
citation
88 4 SCC 534.
1988 4 SCC 534 paragraph 13. No? Paragraph 13.
give me the compilation.
I will give it. I'll give it.
It is prepared
In my chamber, any of the junior that time we used to enter. First, I had to tell them read fast, then come to me. I will not tell name of someone. Don't come to me for 3 days. First, you read all this judgment and sit in front of me. That is, I am talking about 1990.
yes Mr. Bhattacharya, have you prepared anything, any compilation?
Yes, I have. But Bharat Singh is not there.
Yes, add it then.
I will add it. Therefore, kindly, your lordships look into, but keeping in mind your lordships, there are two things. Why unnecessary exercise by this court?
According to you, all exercises have been carried out.
Futile. First question has.
And this is a fact, a reality. A set of appointment has been set aside. It is a fact.
That's a different kind. Listen, that is a corruption issue. But it is not a corruption issue. Simply because one uttering the words corruption is a spicy thing now. I was arguing with Justice Chakraborty. It's a chutney. The moment says every judge has been prejudiced. In Calcutta High Court, every judge is very negative. Corruption. But corruption has to be proved. And Mr. Bhattacharya is going on saying in every court, corruption. Chief Justice said to him, where is the corruption? Proved. Take your seat. And High Court judge is corruption. Is untouchable. I may be corrupted.
Untouchable.
Yes, I may be corrupted if I touch it. If I dismiss the petition, people may say I am corrupted. No. Give it. What is this? What is this going on? I am not saying that 32,000 has been set aside. that in court 26,000 Supreme Court. Supreme Court has said take examination. And we have, when we started it, then 150 matters have been filed by this batch of lawyers. And today I am having 20 matters now I have to go there.
You don't have any matter amongst this bunch of matters?
Huh? I'm assisting.
No.
What the petition or
Because their clients will never get it. And they will not allow to get it by anybody in West Bengal. And you said, you know what has happened. You will be surprised to see. CBI has filed a charge sheet in that case for primary. 6 numbers were given to few persons illegally. And these 6 numbers, because of an order by the court and moved by the lawyers towards saying corruption. We have gone down to that stage.
Under the order of the court, 6 months.
Yes. And who has moved that? This batch of lawyers. Again, when charge sheet is filed, is arguing, see, 6 months illegally has been given. Who has secured that order? This batch of lawyers. Fantastic thing is going on, my lord, in Calcutta High Court, I can tell you. A lawyer who was moved a matter, factually argued the matter, thereafter he became judge. In that matter, one judgment has been given.
What are you talking about?
That judge is saying now why it will not be implemented. He has not heard the matter, petitioner matter. Another matter came to him. He is saying why this judgment will not be implemented. I will file affidavit in Calcutta Supreme Court. See Calcutta High Court. What is going on? There is a limit of doing these things to favor few persons. But I am saying. Tell me, when you are a lawyer, a fact the finance department, then measure. Dynasty proposal 2 at page
এফিডেভিটটা আগে দাও এফিডেভিটটা আগে দাও
God can save this institution.
আরে দূর তেরি কি ভাবে
I can tell you about this. How many years I am? I have hardly 7 or 8 years of TV. Only God will save this. No one can save this. The pain is going on. And the way the jurisdiction is determination is made by whoever comes. Very sorry. We have to be a lawyer. I am telling all of you today. I have to think whether the judge loves white color, whether the judge loves red color, or whether the judge loves saffron color. Where is this confidence?
Yes, what point you have in this?
Come to B. To 1,000 to creation and now the Department of School Education proposes for A. Roman 1,600 supernumerary posts with breakup of 7.50 works education and 800 physical education for absorbing all waitlisted candidates. Correct, man? Now your losses kindly come. Approval of the cabinet short form. 8. The proposal containing para 6 above is now placed before the cabinet for consideration and approval. All details were there are there. Then let kindly come to cabinet decision. Cabinet decision. Cabinet decision will come. They check why cabinet now that order 19 May 2020. While the proposal was state cabinet of including physical and work education teachers and non-teachers starting the performance transfer.
It is presumed now it was approved. Page 9, paragraph 8. This memo, cabinet discussion, last page, approval of the cabinet short form. It is not part of it. It is the right, but it is presumed it must have been.
301. Read petition.
Yes.
See, 301 got it. Now, whereas the state cabinet has been pleased to take decision in its 22nd meeting in equipment and accorded approval bill number 266 dated
5th May 2020.
But this decision is not under cabinet. This order, whichever your lordship still, which has been interference has been called for. So, what is the basic state cabinet decision? If that decision is not challenged, why your lordship will interfere? What is the matter?
No, Mr. Bandyopadhyay, power of the state to create post, I say post, is not under challenge. No one can challenge it. But the decision, how it has been implemented, the process, I want to know from you whether it is open to judicial review.
No, if the decision implementation is a procedural part. Substantive part is the
Decision.
If substantive part is not challenged, why the procedural part is
in service jurisprudence, whether
let's come with a discussion about the law. Law is one thing that applies every why that decision is not under challenge. Decision is not challenged. If it is challenged, then we can look into think whether legally, illegally, arbitrarily, capriciously, constitutionally it is correct or not.
The cabinet decision is immune under the constitution.
No.
As Mr. Sengupta is saying, and it is rightly.
Now let's assume that a cabinet decision, let's take it, I am just arguing against me. If a cabinet decision interferes with my right of Article 19(1) or Article 21, that's fine.
It is open.
Yes, no one is immune in this country. Except one. You know who?
President.
Chief Justice of India on his administrative side when he decides the cross. No one is immune. But I am not arguing to fullest extent the cabinet decision cannot be changed.
There are situations.
Well, my reading of law, my constitutional law which I know, I tell you. No one can destroy my fundamental right. No one. Whoever it may be. Your fundamental right is violated by any decision, whether administrative, whether executive, whether legislative, whether cabinet, all are. Why not cabinet?
More precisely, a policy decision.
Policy decision, if it is based on a cabinet decision, then a policy decision is bad. Is bad. Here is an administrative order. There is an order. Right? This is under challenge. Right? That's on the basis of a cabinet decision. If on the cabinet decision has to be challenged now.
Interesting.
If the cabinet decision is not challenged, but also I am saying that what I have said to you also, my mental regime, my thought of the constitution is this. Gist of the things I am telling you also. No one in the country, including the court, can destroy my right under the constitution, especially under the party law. It is whatever it forms. Whatever it forms, doesn't matter. Therefore, necessary question would be what fundamental rights of the petitioners have been violated that we are also. Let's assume a cabinet is taking a decision. No. From tomorrow, Calcutta High Court, lawyers will not come. Can you not challenge?
Subject to whether it is coming within the field of their such decision.
Decision, even if but decision is correct or decision is.
It will be tested. It will be tested within the litmus paper of the. That is why 162 is subject to other provision. No?
Extensive provisions. That is an executive order. Executive order. This is not a, I will not, what law I know, I just said.
Yes, rightly.
It is not under Article 6. Because it is not in the name of the law. I will not listen. I will not. This thing I have never learned, I will not. Okay. Oh, sorry. Sorry. Now, I'm very sorry. Now, the order is the statutory order, not the. Now, therefore, it is the power conferred under section 19 of the Western the governor has been non-teaching staff. The power would be to of the Western governor is direct. We are going to
Where from you are reading?
301. Order.
You are reading from the cabinet memo?
No, no.
Oh, the notice. 301.
Now, last part, the order is issued with the concurrence of the finance department. It is pursuant to the approval of the state cabinet number. It is to be approved. So this detail has not been said. Last paragraph.
And why Mr. Advocate General argued that even if it is not approved by governor, then it is not necessary that every decision of the cabinet should be approved through governor. Now, if you come to this,
But we can argue. I am not going to argue that part because I am not.
it is there.
I am not.
Mr. Bandhavada, please come to page 3, the notification, rather the cabinet decision, discussion. Are you getting anywhere that it was approved by governor? This, no, that notification is right. Are you suggesting?
Governor has not got signed.
With the approval of the government?
Not required. Approved by the governor.
No, not necessary. If you come to page 9, approval of the cabinet short for. Approval of the cabinet short for. If you kindly see once, proposal of cabinet in para 6 have now been placed before the cabinet. And the
approval of the cabinet
short for.
Yes.
Therefore, the cabinet approved, as you have read out, approved. In between, whether this approval was routed through governor.
Approval is not needed, not.
It was factually, because the notification says with the approval of the governor.
No, that is.
3-1, then 1.
And you see that is in exercise of governor.
Please to create.
Governor is to create. Now taking this.
For that reason, it is need not be placed before the governor.
No, I don't think so. Or governor is required to be consulted or not, I don't know. Whether that allegations are there.
No, I need to know that. The route. What is the route? Because as you.
It needs to be clear. So 166 of the constitution.
I will not engage for a long time. Please consider.
Or can you say 166?
Hmm.
All executive action of the government of a state shall be expressed to be taken in the name of the government. If it is in the name of the government, 166 is satisfied.
For that reason, no.
Second, it will be clear. Order and shall made and executed in the name of the government shall be authenticated in certain as may specified in rules to be made by the government. There's a rule. There's a rule which is called business rules of business. And otherwise, I am not calling also on the ground that it is not an order or instrument made or executed by the government. The governor shall make rules for the more convenient transaction of the business of the government of the state and for the allocation among ministers of the state to.
So it is not open to
No,
challenge.
it is a business rules have provided and business rule is existing. Time to time it is being amended. But it is not needed that every time it is ready to go.
Not necessary. And that exactly Mr. Dotto argued. That.
Take it. Take honorable judge will take oath. That has gone to the government.
There are rules will provide which is to be gone to the government. Exactly that Mr. Dotto argued in that line.
Now we are trying to see this is not challenge. Even if it is challenge, why it is bad? This is why it is bad. Now what is the normal? Normal rule is that after expiration of panel, no one gets. Whether existing or new, it is normal. Suppose my name has waitlisted, panel has expired. I am saying coming to your losses for your losses will no, you are going to have a right. But can the government is not in a position who can legislate the law, who is having a power to make a special class to make this waitlist? Not a single man, all the waitlists. What is the harm on that? Is it taking it? Anybody's? I can understand a case, but let me tell you. I can understand a case that not these persons, but new persons who may got the chance, have they not been appointed in that case? Our right is being taken away. And what is supernumerary post? Supernumerary post is, my lord, is a temporary one. When vacancy will be created, they will adjust the vacancy. And for creation of an adjustment, they don't get enjoyed seniority. Right? There were who could have challenged it. Aspiring candidate to be appointed.
Or the similarly placed candidates who are already in employment.
No, not the employment has no right.
Supernumerary.
Judgment is there. Let's assume my lord X has got the employment, on the basis of panel path. I am in the wait list. Right? Super and numerous posts have been created. I am a temporary one. Let's assume. In the meantime, another advertisement has been. Other persons have come. Correct? Now, supernumerary post persons are being regularly appointed. So, ABC case. Although I was B, C has come. B seniority will be counted after C.
That was the effect of this
That is it.
appointment.
Until the trace post comes in, they cannot be adjusted.
Last question to you. Whether this is a part of 2016 selection process? 2016 selection process?
So first part.
This one. There was a selection process. No, I'm not talking about 19, 11, 12, Group C, Group D. For upper primary selection process 2016, this creation is a part of that selection. Then, first understand the question, then guide your senior. 2016, there are two separate, 9, 10, 11, 12, Group C, Group D, we are not concerned about. a selection process for upper primary level of schools. Within this, another thing, work education, physical education. I want to put you a question whether this work education and physical education is a part of 2016 selection process of upper primary classes of schools.
No,
Then it is a new selection.
no. Selections was also separate selections.
For upper primary,
No. Or what? Physical education.
it has no connection with the upper primary. No. Sir, upper primary level of schools, there was a selection process in 2016 by virtue of a employment notification. Within the same employment notification, assistant teachers for the classes up to class 8, and work education, physical education teacher for that class. It is under the same advertisement or not?
Same advertisement separate. That is a 10% quota.
Upper primary rules were there, covering everything. Selection was conducted separately for normal and upper primary for work education.
But by two separate appointment notification or the single?
Two separate.
But under the same rules.
Under the same period.
Therefore, 2016 same rule applies to this all.
Yes, this is the rules applied for.
That's all.
But good question. Since they have lost good question would be whether these persons were related in Pura practice. Entire panel has been appointed.
It was argued to meet the agitation in the street. These posts have been created.
Yes. But you and try work. Government has to. Master, I am not appealing for the state now. Government has to.
You may not, but you cannot remove your jacket. Represent.
Government has to take action.
Now it's decision gulo to.
10 years there was no selection. The 2 or 3 judges that
Just give me this bunch.
because I am giving it to you also can note down and
Yes, yes, that is there, I think. Where is the compilation? Give it. Then, this again, Mr. Rahul, you did not do it. You have not done justice to your name. Give me an index for which point you are, on which point you are giving it, like the other one. He doesn't have that time. Your dad junior has not that much time.
He is my now teach at my good age.
No, I appreciate he is sustaining you.
Yes, yes.
No one is there to
No.
young. Of course. Why are you just wagging this credit in your favor? Don't try to. Don't try to. Mr. Rahul, please do it with the paragraph number and the proposition on which your senior is citing this. And this one I am keeping, I understand. The AI.
I will give it in the notice, sir. There's no
Just give it in a note. I got your crux of your argument. Yeah. Ita.
2011 6 SSC 59, sir. 130. Up to 130. And to paragraph 18.
Paragraph
18. Page 142. As rightly pointed out by Mr. Altaf Ahmed, without any arguments having been made, or without there being any question raised by any person as to the validity of the cabinet decision is concerned, and without the same being a question or any relief sought for in the issue, the High Court has gone into the decision of the cabinet having taken place after the judgment was the decision of the cabinet general or not to be interfered with the judicial review so lightly as has been done in the present case. The questioning of the cabinet decision without analysis of pros and cons matters is to restrict the state's constitutional authority. But the order outfall of the cabinet, nothing more than that.
So, in the absence of the follow-up actions cannot be. Mr. Rahul, I have to give it to you.
Yes,
Please. We can do it today. Just press it and give it. হ্যাঁ দিদো একসাথে করে দেবে চাই দেখো তো rush to the another court.
Becoming mad. No one will allow to continue with the process.
The new selection. This is a new selection test.
Anyhow, just restored. I have to give explanation every day that whenever Justice Sanjay Mr. Vandopal, we will hear from him. Don't go whether it is not done. See my problem.
Examination is over.
Okay, result has been declared.
No, there is no injunction, I suppose.
Every matter. Give this 5 marks, give this 10 marks, this is the way.
Mr. Bandyopadhyay, why are you criticizing? Everyone is aspiring for the job, the only government job available. Once I told you that it is for giving.
When issues are pending,
Not to touch. Maybe collaterally, that is why this matter.